In National House Building Council versus HODSON Developments Limited and others, the court refused the first defendant's application for relief from the sanction imposed by Rule 3.14 for failing to file a costs budget. The first defendant, a development company, missed the 30th of May 2025 deadline after its solicitors terminated their retainer. Applying the three-stage test from Denton versus White, Recorder Singer KC found the breach was serious and significant, causing the need for an additional hearing. No good reason was established. The director had received clear warnings and should have ascertained the deadline, despite being preoccupied with a separate planning inquiry. Working out the deadline would not have been a difficult exercise. Considering all circumstances, including the need under Rule 3.9 Sub-Rule 1b to enforce compliance with the rules, the court held it would not be manifestly unjust to maintain the sanction. The first defendant was therefore treated as having filed a budget comprising only court fees for future costs, with estimated costs of approximately £260,000 affected. Incurred costs remained unaffected by the sanction. Quote, "Whilst the date of the 30th of May was not in terms set out in that letter, and Mr. Letman rightly points that out, nor did a later email in May in terms point that out, nevertheless, it does seem to me that it would not have been a difficult exercise by any stretch of the imagination to work out when 21 days before the 20th of June was. Or indeed, as a responsible director of a company, to ask when it was. It does not appear that Mr. HODSON actually did that at any time."
For a detailed summary of this decision, visit tmclegal.co.uk.